Hello, if someone gets arrested, what is the process that follows that arrest? Stay tuned, and I'll answer that question.
That Corbin and Corbett legal team fighting for the rights of the people. That father-daughter team investing in the youth when the system ain't treating them equal. Providing truth for our people, we able to reach them. So anytime you get accused for a crime and Lord knows you ain't do it, we here to get you through it. Exemplifying prudence and glorifying God, making sure you're compensated for other people's doings. Our vision is to be one of the best. We're small enough to focus on your matter throughout the neighborhoods of Dallas. Working constantly and making sure your rights are protected. A firm team of lawyers, aggressive, effective. The team that has your back in the courtroom. Two well-spoken black lawyers in the courtroom. Investing time and resources when it's evident that you were treated wrong. Now you walking out of Dallas courtroom with a settlement. Corbin and Corbett, the father-daughter legal tag team that has your back in the courtroom. Our purpose is simple. To obtain a favorable outcome for each client and glorify Christ in all we do. Our vision is to be one of the...
Hello, I'm Attorney Augustus Corbett. I practice personal injury, criminal defense, and family law in Dallas, Texas, and throughout the state of Texas. The question today is, after a person gets arrested, what is the legal process that typically occurs here in the state of Texas? So let's walk through that. I want to take you through that. I've been doing this a long time. And so I want to share with you what typically happens. So first of all, the arrest probably started with an encounter with a police officer, with law enforcement, with a deputy sheriff, with some peace officer. And that resulted in an arrest. The arrest could have been made on the spot, where the police officer, the law enforcement officer thought they had probable cause to make the arrest, or they could have gotten an arrest warrant signed by a magistrate. And either way, an arrest was made. Now, the person was taken to jail, and once that individual arrived to jail, usually what happens is within 24 hours, that person goes in front of a magistrate. We call that the initial appearance. And the purpose of that initial appearance is to inform the individual what charges they face and what their bond amount is. Again, that's the initial appearance. Let's assume that the individual bonds out. And by the way, if they don't bond out and it's a Class B misdemeanor or above, then they are transferred to the county jail. The next step is, if they have hired an attorney or an attorney has been appointed to them, that attorney can request what we call an examining trial. The purpose of the examining trial is to force the state to show that there's probable cause for the case to even go to a grand jury, assuming that it's a felony case. If the judge, after hearing the evidence the prosecutor puts forth, believes that there is probable cause, then the judge will send the case over to the grand jury. Now, once it reaches the grand jury will make the same determination, and that is whether or not there is probable cause to return a true bill of indictment. The grand jury can also say, no, there's not enough evidence to return a true bill of indictment, and no bill the case. Or the grand jury can reduce the case. By the way, the examining trial, to go back to that for a moment, serves another very important purpose. And that is, even if the case is sent over to the grand jury, the criminal defense attorney would have gotten the opportunity to hear what evidence the prosecutor has, even before discovery. That is a huge advantage of the examining trial. Prosecutors don't like to hear us say that, but it's true nonetheless, and it's been done many times here in Texas. If the grand jury true bills the case, the grand jury issues an indictment, then the case is sent over to the court system. And now the individual has to start reporting to court every so often. Now, once the case gets to court, the criminal defense attorney and the prosecutor begins the process of negotiations and discovery. Discovery is where the prosecutor has to hand over to the criminal defense lawyer all the evidence the state has against the defendant. On the other hand, the criminal defense lawyer doesn't have to hand over any of his evidence or his information or anything else to the state. Not only does the criminal defense lawyer request and receive discovery, but the lawyer will also be doing an investigation. In cases that we handle, we typically hire an outside investigator who is experienced in investigations to handle all of our investigation. But that is critical. The discovery and the investigation in a criminal case are very, very important. Now, by the way, if the individual, the defendant, was not able to retain a lawyer, when that case hits the court system, the court is obligated to appoint the defendant a lawyer. If he's indigent and cannot afford a lawyer, the court will appoint a lawyer, or the court will assign a public defender. There may be public defenders in that court, and they will begin to represent that defendant. At any event, that defendant will have a lawyer. Now, he can reject the lawyer and represent himself, but that's ill-advised. At some point in the process, the criminal defense lawyer and the prosecutor are going to negotiate a plea bargain. Most cases in the criminal justice system are resolved via plea bargains. There are just too many cases in the criminal court system to take to trial. So there's incentive for the prosecutor to put good offers on the table so that they're not having to try all the cases that they have. It is up to the defendant whether or not he or she wants to accept that plea bargain. That is not the job of the attorney. Our job is to communicate what the plea bargain offer is, to thoroughly investigate the case, to review in depth all discovery, and then offer the client, the defendant, the best legal advice possible in light of all the information that the criminal defense lawyer has. And the final decision as to whether or not the defendant want to take his case to trial or whether or not he want to plea it out is entirely left up to the defendant. We tell our clients, that's your choice, because whatever the results are, you and you alone have to live with them. If the defendant decides to take the plea bargain, then we take the plea bargain in front of the judge, and we inform the judge that the state and the defendant has reached a plea agreement. However, the judge is not bound by that plea agreement. The judge can reject it, and judges have rejected. I've had some of my plea bargains rejected by judges. So the judge is not bound by that plea bargain. But if it is accepted by the judge and the state and the defendant agrees to it, then the case is resolved, the case is disposed of, and the defendant is able to move on with his life or her life. If the defendant feels strongly or if the evidence is weak, the state has weak evidence, if the case is what we call a triable case, then the case may go to trial. Trials can be done in front of judges or juries. We prefer juries. And that's because the state has the burden of proving its case beyond a reasonable doubt. And we just have the burden of showing one of the 12 jury members, at least one of them, that the state has not met that burden. And if we can get one of them, at least one of them, to agree with us that the state has not met its burden to prove each element of the crime that it has accused our client of, then we can at least get a hung jury. In some cases, we get not guilty verdicts. That is always the goal, but we can't guarantee it. So the final resolution of the case, if there is not a plea bargain, is a trial. A trial has two phases. It has the guilt and innocence phase, and it has the punishment phase. If a person is found guilty, the jury finds a person guilty, then the case moves to the next phase to determine what the appropriate punishment should be. So that is roughly the criminal process here in the state of Texas once a person is arrested. Now, obviously, it is much more complicated, convoluted than what I just went through. But that is the basic process. If you're facing a similar matter, give us a call. Our phone number is 469-726-2626. Again, that's 469-726-2626. And that number is probably running across the bottom of your screen. But in case it's not, 469-726-2626. I hope that you got something from this video. Thank you.